Good afternoon, Your Honor. Amanda Mulaney for the Commonwealth.
Aidan Mulaney.
And good afternoon, Your Honor. Stephanie Soriano on behalf of Mr. Fonseca.
Good afternoon, Attorney Soriano. So this case was put over to today for status. Where do things stand?
Your Honor, it was put on for today for status. The court had ordered a 15A evaluation. Your Honor sort of heard a secondary part of that. We put it over for today because counsel was looking to have a private evaluation done by her doctor.
Right.
It's my understanding that the evaluation has been done, but the report is not done.
Okay.
So we would just, I think, need a status date maybe in late July for that report. And then if the court would allow, I think it would be best to put it also on for a September date where we can do the full hearing on competency. The Commonwealth will be hiring our own expert as well.
Okay. And will that give you enough time if you receive the, when do you expect to receive the report?
I think that ADA Cook spoke with her and she indicated Monday it should be done. So I would think late July should be plenty of time to get the report, read it, and have an expert retained.
Okay.
And if not, we'll have that date to make sure that things keep moving.
Okay. All right, Attorney Soriano, were you in agreement with that?
Yes, Your Honor, I am. I did communicate with the doctor this morning. He did indicate that he would be getting the report to us. And he did relate some of his findings that will be in the report that I gave to ADA Cook. If Your Honor would like to know what those are, he essentially found him not to be competent and not able to be restored. So that will likely what the report will say next week. And I think a late July date would be a good idea. I did tell the Commonwealth my client is obviously available at any time that they need him evaluated.
Okay. All right, if you did dates already?
I have not, no. Attorney Soriano, we were looking for late July. I think that any day in that period is good for ADA Cook and myself, as long as
Sure. How does July 25th sound?
Was that July 25th?
Yes.
Yes.
That works.
Okay.
And then I think any date in September with the exception of the 8th or the 24th.
That's for the full competency hearing?
Yes.
Should we do that 9 a.m.? Okay. So that will be a Monday or Friday.
I could
The
do
23rd?
Of September. Is this of September?
Yes.
Yes, September 23rd at 9 a.m.
Sure.
Okay. So, Mr. Fonseca, by agreement, your matter has been scheduled to July 25th at 2 p.m. for status and further continued to September 23rd at 9 a.m. for a competency hearing. Thank you.
Thank you.
Those will be in person.
Yes, thank you very much.
Thank you.
I do believe we can do number 7, the bail review. Are we ready on Mr. Kelsey? Yes. Okay. Next before the court is the petition of review of bail of Edmund Kelsey Jr., 24 BP 68. Mr. Kelsey will be entering the courtroom momentarily and is represented by Gerasimos Anzalatis. The Commonwealth is represented by Assistant District Attorney Thomas Caldwell. If the parties could please identify themselves for the record, beginning with the Commonwealth.
Thank you, Madam Clerk. Good afternoon, Your Honor. Thomas Caldwell on behalf of the Commonwealth.
Good afternoon.
Good afternoon, Maki Anzalatos on behalf of Mr. Kelsey.
Attorney Anzalatos, good afternoon.
I have a packet, Your Honor, that was originally submitted at the 58A but I think that is also relevant to the question of bail. So I was just going to pass it up. It's a couple of letters and a short memo.
Okay.
Thank you.
I'll tell you what, I
doubt that made it up here, so.
the only thing that I have is the complaint, the state police report, and then the defendant's court of probation record.
Right. Yeah, this isn't the 120 days just expired, so this is an appeal of the bail that was after that.
For the record, Mr. Kelsey is present.
Good afternoon, Mr. Kelsey. All right. So Attorney Antolanos, we're here on your request for review of bail that was set in the district court.
Yes.
I'll
So
hear it.
just by way of procedural background, the Commonwealth petition for dangerousness was allowed. Mr. Kelsey was held for 120 days. That expired on the 16th, I think, or last week. And there was a bail argument. We were requesting bail in the amount of $5,000 to $7,500. The Commonwealth was requesting bail in the amount of $25,000. The court so we're also asking the court to vacate the home confinement order as well. This is a search warrant case where the police found a significant amount of narcotics and I think $32,000 in cash that was seized and now is in the property of the Commonwealth. The reason that a lower bail is appropriate, I think there's a handful of reasons, but the first fundamental reason is that this is a rare case where Mr. Kelsey's relatively serious but short record, I think actually supports a significantly lower bail. And the reason I say that is you'll notice that there's 3 cases that are pretty short in time in Plymouth County. That was Mr. Kelsey's first real foray into the criminal justice system. And he was actually out of custody for a significant period of time during the pendency of those cases. I reviewed the docket on mass courts and see that mass courts indicates that he appeared 3 times when he was out of custody on like and similar charges. Mr. Kelsey actually has a memory of going a 4th time. I learned long ago to trust my clients over mass court stuff, but either way, it was 3 or 4 times. And so he has a proven track record of appearing in court on serious superior court felonies, and I think that that matters quite a bit. You'll notice on his record, there's not an otherwise long history of convictions. There's no allegations, let alone convictions of any violence or any crimes with victims. Mr. Kelsey's a young father. He has a daughter who's very active in her life, and in fact, one of the letters that I passed forward to Your Honor is a letter of support from his child's mother. A real good working co-parenting relationship with the mother of his child. They are not together. And I think that says a lot about his stability and sort of his character, that he still has that positive relationship with the child's mother. In addition, there's also a letter from Mr. Kelsey's father. Mr. Kelsey's father's a local union member. He's who Mr. Kelsey would be living with. He's employed full-time and has expressed interest in trying to help Mr. Kelsey get into the trades if that's something that he's interested in doing. In addition to his father, there's a significant family support, many of whom are in the courtroom in the back. His aunt is here, his grandmother is here, and these are all individuals that would be present in Mr. Kelsey's life were he out of custody. The backstory of sort of Mr. Kelsey's life, I think, is significant here. It's outlined in a lot more detail in the memo I passed up, but Mr. Kelsey was actually, as a teenager, was doing incredibly well, was en route to college with a football scholarship. He was a sort of star high school football player. And his mother passed away unexpectedly in a car accident when he was a teenager. And everyone I talked to, not only Mr. Kelsey, but also all of his family members, sort of tell the same tale, that was really the beginning of a decline for Mr. Kelsey, mental health-wise, and sort of what quickly followed was his, beginnings in the criminal court system. One of the things that I suggested in lieu of detention at the original 58A hearing is that a condition be set that Mr. Kelsey pursue mental health counseling for the trauma that is still lingering from his mother's death. I'm not sure under Norman if that can be a condition of release just on a straight bail, but what I will say is, regardless of whether it's in the court orders or not, Mr. Kelsey has already talked to me about beginning to work with the social work staff in my office to get the ball rolling there. Recognizing there's the significant penalties and the serious nature of the offenses, I think the presumption of personal recognizance, which we're not after personal recognizance, but the presumption of personal recognizance, the long track record of his appearance in court, the strong family support, he has no ties anywhere else, all really work in favor of a bail, I think significantly lower than $20,000. Like I said at the beginning, I think the family could make somewhere in the neighborhood of $5,000 to $7,500. Anything north of that is going to be a real stretch for them. So for all of those reasons, we're asking that the district court bail be revised to somewhere in the neighborhood of $500 to $7,500 with any conditions the court sees fit. I would just ask to vacate the home confinement order because I actually think that it interferes with individuals trying to get their lives together when they're sort of tied up in the house all day. But Mr. Kelsey could certainly abide by a curfew if the court wanted that.
And the III reflects a case out of Michigan as well, too. Are you familiar with that?
I've actually never seen a III in this case. I can take a look at it and speak with Mr. Casey. That didn't come up in the lower court. Yeah, one of the things that Mr. Kelsey has spoken to me about is he has a sort of a burgeoning music career, and he was actually in Michigan for work. I think it's just a driving charge, like a reckless driving charge. But he acknowledges that that's in.
Okay. All right, and it appears that the prior cases in Plymouth Superior, that they were wrapped up together.
Yeah, he took up a state prison sentence that resolved all three as part of one resolution.
Okay. Thank you. Commonwealth?
Thank you, Your Honor. The Commonwealth's requesting that the bail remain the same, $20,000 cash. And just to clarify, not only was home confinement ordered by the district court, but there's also GPS in conjunction with that requirement if the defendant makes the bail, as it's currently set. Your Honor, just very briefly in terms of the facts, I know my brother indicated this was a 6-month investigation by the Massachusetts State Police, resulting in, as my brother indicated, a search warrant being executed in Norfolk County on McCusker Drive, what we would allege is the apartment of the defendant. There was a significant amount of drugs found at that location upon execution of the search warrant, but also a firearm and other drug paraphernalia, including scales and cutting agents, the Commonwealth would allege. In addition to that, a firearm was discovered within the apartment. What's important to know is that the defendant in this investigation, the Commonwealth alleging 2 undercover sales to a Massachusetts State Police trooper in Braintree, in the town of Braintree in Norfolk County. In addition to that, as part and parcel of this investigation, there were 5 other sales in the Plymouth County area. The defendant, I can't speak to the Plymouth district, has not been charged there, but there were 5 distributions to also an undercover trooper in that area. And one of the 2 sales in Norfolk County was the sale of trafficking rate of fentanyl. So, Your Honor, as the court knows and can see from the complaint as it stands, the defendant is facing a series of mandatory incarceration for the drug offenses and the firearm. Again, I can't speak to the Plymouth district. The matter has not been indicted as of yet. Commonwealth is still waiting an outstanding ballistician cert and scientific testing. State Police tells me that the ballistics will be completed by May 31, and there is already scheduled a grand jury date in June for Mr. Kelsey.
So it's your intention to present it?
This is the intention of the district attorney to present that matter to the grand jury in June 11th. I've shared that with my brother and the lower court. Commonwealth would say, and noticing the record, Your Honor, and the lack of defaults, however, given the seriousness of this offense, what I would submit at this point, the strength of the Commonwealth case based upon our knowledge of the circumstances, that a $20,000 cash bail is reasonable and significant to ensure the defendant's appearance in this court. And in addition to that, I would ask that the GPS and home confinement be added as a condition if he shall make bail.
Thank you. I'm going to take the opportunity to review the memo that you submitted this afternoon, as well as the letters in support, and I'll get you a decision by the end of the day.
Thank you, Your Honor.
Thank you.
Your Honor. Thank you, Madam Clerk.
Mr. Kelsey, your petition is taken under advisement.
Okay.
May I call the next case, Your Honor?
Yes, please.
Next before the court, numbers 5 and 8, Commonwealth versus Aidan Kearney, 23 CR 313, 24 CR 43. Mr. Kearney is present and represented by Attorney Timothy Bradl. The Commonwealth is represented by a Special Assistant District Attorney, Robert Cosgrove, The matters are on for motions for sanctions and discovery compliance. If the parties could please identify themselves for the record, beginning with the Commonwealth.
Good morning, Your Honor. I'm Special Assistant District Attorney Robert Cosgrove. I entered an appearance yesterday.
Afternoon, Attorney Cosgrove.
Good afternoon, Your Honor. Timothy Bradl on behalf of Aidan Kearney. Your
Bradl.
Honor, my client Aidan Kearney, and this is
Kearney.
specifically our paralegal. If you already
Good afternoon. That's fine.
Thank you very much.
Thank you.
There's several motions on the docket today, Judge.
Yes. And are both sides prepared to address each of the motions?
I would say I am variously prepared, Your Honor, depending on the motion, and I'll indicate that as we go along, if I may.
Okay.
Mr. Bradl has, I think, a fairly lengthy list of things that he would like to address, so I'm happy to defer to him as to the, and to the court, of course, as to the order at which we take the particular motions up.
Okay. And I'll just note for the record as well, too, that obviously Special Assistant District Attorney Cosgrove used to be a member of the Superior Court bench, but we never worked together on the bench. So I just want to make that clear that there's no issue that I see. Attorney Bradl, are you raising any issue in that regard?
No issue whatsoever, Judge, and I should also say I've tried cases in front of Judge Cosgrove, and I'm happy to litigate against him as well. It's perfectly fine with me.
Okay.
Thank you.
Thank you. All right. So one of the matters that was outstanding from our last day in court was response to Attorney Bradl, your papers 6 and 16 in the 2023 case, which was the Commonwealth's reply to the defendant's motion to strike in reference to remedial orders and other matters. I know that there was a response that was filed to that by Attorney Mello.
Correct.
And that I believe that there may have been an issue, at least in the copy that I had received as to its completeness initially of what was filed. I'm not sure if you had received a complete copy of the filing as well.
I did get it back to the judge, and it was very brief, and it's not going to detain me in terms of what I want to argue today to the court. And I was expecting him to be here in consonant with the court's order for people to be here in person today. That motion was on the docket. He had to have 3 deadlines before he complied with what he faxed to me and apparently gave an incomplete copy of to the court. And I'm here today before this court looking for satisfaction on my motion. His initial motion was denied.
Let me just pause you for 1 second. Attorney Cosgrove, are you ready to address that motion?
I think it would be better if it were addressed by Attorney Mello, Your Honor, but I do have some things to say about it.
Okay. All right. Well, why don't we address that, and I'll give you an opportunity of, and do we know?
Could I just say preliminarily, I became aware of the motion yesterday, and I came over to the court to get a copy of it, and discovered Attorney Mello's response. And in going through the papers in the court file, I discovered that apparently he had faxed over a response for filing with the clerk, and that for whatever reason, whether it was a misfunction on the fax machine or in scanning it in or whatever, the court appeared to have only a partial copy. I did contact Attorney Mello by phone yesterday. My understanding is that he did fax over a clean copy, and I'm hopeful that Your Honor has that before him.
I did receive the complete version, so I appreciate your efforts on that. And do we know, we're not going into any personal issues, what Attorney Mello's availability is going forward?
I can't say that with any certainty, Your Honor. He is not here today as a result of medical problems, which have been ongoing and recurring. When I spoke to him yesterday, he said he was in, I think the words he used were recovery mode again. So I think he's hopeful that he'll be back to good health, or at least workable health pretty soon, but I'm sorry I can't be more enlightening to you than that.
No, I appreciate that.
All right, a couple of things on that, Your Honor, was that the first thing is that we selected this date with Attorney Mello, you know, fully aware and cognizant of his medical issues, and this is the date that he agreed to. So whatever's going on.
My memory is that he also informed the court at our last date that he had a surgery that was scheduled, I believe, for last week as well, too. So he did make us aware of that.
You know, my fuse on this has grown very short, Your Honor. And, you know, this is the fourth or fifth court date where, you know, Attorney Mello had his side of this issue fully and fairly litigated against me, by surprise, I might add, bringing witnesses to court without any notice to me from the jail, who testified without, I had no prep, no cross-examination whatsoever, that smeared me in open court about a simple mistake I made that had absolutely no practical effect on anything in the case whatsoever, and was made into some huge issue that was published in local media that damaged my reputation. I still have people coming up to me thinking that I somehow got in trouble because of Attorney Mello's ridiculous filings. And so I filed a cross motion for sanctions against him for several things. The first thing was publishing this motion without any regard for adequate investigation, without any actual truth to it, smearing me as if I was trying to manipulate the sheriff's office into confidential phone calls. So once I delved into it, I found that there were all sorts of avenues at the sheriff's office where all kinds of people could have confidential conversations through attorneys, through paralegals, without being a lawyer. The whole thing was a total sham, Your Honor. And so I filed my motion for sanctions against him for doing that to me. And in addition to that, Your Honor, in the body of his motion on the first page of it, he published my private cell number, Ms. Healy's private cell number, and Ms. Altman's private cell number in black and white on the first page of the motion, and published that to this court and put it on the docket. And from that day on, my email address has been hacked. My Facebook is closed down. I have all sorts of things that I can't get into to this very day. And I'm not going to belabor it because I've given the court a paper record on it. I've filed an affidavit, Ms. Healy's filed an affidavit, and Ms. Altman's filed an affidavit. These women have suffered really nasty text messages and emails to them as a result of this. It was insanely reprehensible what he did. And that's just the tip of the iceberg, Your Honor. The conduct that he engaged in, publishing our private numbers, causing us all this harm, is exactly the same conduct that he indicted my client for. There's an indictment against my client for showing on his show, his internet show on video, a phone number of a state trooper, which resulted in him getting all sorts of hassles on his phone. That is the entire statement of facts relative to that indictment for felonious 13B witness intimidation against my client. And he does the exact same thing times 3 to the defense team, which is an eye-popping conduct, if you ask me, Your Honor. And and that dovetails into my motion to get him disqualified from this case. How do we deal with that? Is he going to take the fifth over this? How can he justify that he did it to 3 people and he indicted my client for the exact same conduct against one of his? What do we do with that fact? is he gonna be an expert witness? Do I call him as a witness to explain why his conduct is okay to the defense team and Mr. Kearney's conduct is not okay? Why is his conduct felonious witness intimidation? And why does this mellow character get away with doxing all three of us, totally innocent people trying to do our jobs? He has this mentality that equating the defense team with what he perceives our client to have done. And it's some twisted form of revenge or some bizarre attempt to get payback for his trooper. It's just absolutely mind-boggling. It's unethical. It's gross misconduct. And because of all that, Judge, I have two requests asking you to disqualify him from this case. And on that point, Your Honor, I will say that that may become moot because the Commonwealth today served me with text messages from Attorney Mello to one of the complaining witnesses here, Ms. Gattani, where he tells Ms. Gattani in a text message that he is withdrawing from the Aidan Kearney case. So I don't know what's going on with that, but I just received that. And, you know, if that's the case, let's have him fish or cut bait. Withdraw from the case within 7 days, or I want him disqualified. And that's my request. This insane, outrageous conduct needs to be answered by the court, and I appreciate that Your Honor is hearing this, and it's something that's been gone on through 3 deadlines for him to respond. He's ignored it. He's hiding behind his condition, and I am before the court asking respectfully for satisfaction on my motion, Your Honor. Thank you. And also there's this section on the apology, which I'll leave to the papers. Thank you.
Thank you.
So, I would, somebody coming into this, obviously I represent the Commonwealth. I can't speak from an entirely objective point of view, but looking at Mr. Mello's motion and then looking at Mr. Bradl's cross motion, I would characterize it as something of a tit-for-tat motion. Mr. Mello was looking for sanctions, apparently, and Mr. Bradl responded by escalating the argument. I think that in reading Mr. Mello's response as filed by the court, he sets forth the factual basis that prompted him to file the motion, and one may agree, the court may agree or disagree with his decision to go forward on that, but I certainly think that he set forth the factual basis for his doing so, and I think that the exhibits that he attaches to his motion certainly enable the court to make an informed decision. I would suggest that the court could probably deny Mr. Bradl's motion on the paper submission, but I would also suggest that it's been maybe 7 years or so since I've had occasion to deal with a motion to disqualify counsel, but it's a pretty heavy lift, as I recall the case law. And if the court thinks that there is some merit to this motion, I think you need to have an evidentiary hearing with Mr. Mello here, and I think the court would need to make findings of fact. And I think, frankly, the Commonwealth would have to seriously consider a 211-3 appeal if the court is going to be in the position of removing the prosecutor selected by the district attorney. That, of course, would be a decision for him, not for me.
All right. I agree that it does would require an evidentiary hearing on this particular issue. I know that there was a case recently out of Hampden County that was addressed by the SJC on a prosecutor who was potentially going to be a witness in a murder case that was going for trial out there. So that, I think, is going to set the standard of what needs to be addressed in terms of disqualification. So
if I could just add, Your Honor, I can't say this with certainty, but I am reasonably certain that the email purportedly from Mr. Mello talking about his withdrawing from the case was not actually sent by Mr. Mello, but was sent to Ms. Gattani, I believe, with someone pretending to be Mr. Mello. So I'm not at all sure that that's a genuine email, but certainly it indicated that he was planning on withdrawing within a week, and substantially more than a week has passed since that time.
Okay. So Attorney Bradl, we had your motion, and there was actually discovery motions filed in the 23 and the 24 case seeking discovery, and I recall your arguments from the last date as to lack of discovery that had been provided at that point, and your inability to file either motions to suppress or motions to dismiss. I did see that ADA Cosgrove, that you had filed a letter that was sent to Attorney Bradl addressing discovery issues and your steps to address that. Do you want to be heard on that?
Yes, and I also provided Mr. Bradl with some additional discovery today, including grand jury minutes and a copy of the text that I alluded to in my letter from Lieutenant Tully. I did have the opportunity to speak with Attorney Bradl for a few minutes before we came up to address your honor, and he's provided me with a updated list of things that he's says he's missing. A lot of the information that was provided, maybe the lion's share was provided on some drives, and I'm advised that he has trouble opening some of those documents, or that the defense believes that certain things are missing. So I have a fairly, I think it would be fair to say, substantial list that he's provided me with today. And I've indicated to him that I will go right to work on looking into these things and either get them provided for them, or explain that we don't have them, or why we can't provide them. But I regret that I can't report that discovery is complete, but I'm working on it and I've done my best.
Attorney Bradl, do you want to be heard on that?
Yes, Your Honor, and I appreciate that counsel on the case is going to probably have a very different rate of production, shall we say, of discovery than prior counsel, and I'm not too worried about it. We've given the court the same chalk that I gave to counsel. It's the second one we've given you relative to the things we're looking for. And we are greatly prejudiced, Your Honor, in that this is really a kind of a case of first impression where, you know, we contend that journalistic activity has never before been a basis for felonious witness intimidation. So, you know, there's a lot of things that we need here. And we are very eager to relieve Mr. Kearney of this prosecution through a motion to dismiss or a motion to suppress. And we can't do so for all this time, for months and months and months, because we don't have the full copy of the grand jury. And I appreciate counsel trying today to give us some grand jury, but we already had that one. And we put it in here, what we actually do need. And we need the exhibits. And, you know, we need a full copy of it, and we need a representation from the Commonwealth that we do have everything in terms of grand jury. So I can do those McCarthy, Odell motions and motions to suppress.
So I did at our last date also instruct Attorney Mello to file a certificate of discovery with the court as well, too, as to what has been provided.
Correct. That was the first thing we put on here. We don't have any discovery notices. And you know, I do need a representation at some point, and I'm going to ask for it within 14 days, Judge, or I'm going to move for failure to prosecute. dismissal for lack of prosecution because, you know, Mr. Kearney deserves his chance to get out from under this case. And I'm not talking about present counsel for the Commonwealth, but the Commonwealth itself has been slow walking this case to keep Mr. Kearney away from the Karen Reed murder case that he's been seeking to investigate. And there's been all sorts of hurdles on that, and that's just been continuing. And he deserves to get that motion to dismiss filed, and we want to talk about the constitutional issues and the Supreme Court and how most, if not all, of his speech in these cases, Your Honor, has already been covered by the Supreme Court in Brandenburg, in Watts. It's political hyperbole. It's First Amendment protected speech. It should not be the subject of a jury trial or any kind of trial. It needs to be addressed by a judge applying the First Amendment and the Supreme Court precedent. There's no way they can get past that in my legal view. And we're deprived of the opportunity to litigate that. We've been in a holding pattern for all this time. Your Honor said May 8th, nothing happened. Your Honor said notice of discovery, nothing happened. And again, present counsel accepted he wasn't there. It didn't happen. You know, these are all court orders that have been ignored. Like I said, 3 deadlines for my motion for sanctions, ignored. You know, and he gets the benefit of it rather than gets a sanction for it. And I'm asking that, you know, when a motion is not adequately responded to, when things are ignored by the court, you know, the court has options, and the court can deem a motion allowed for failure to respond. The court can provide sanctions. If the government is not providing fundamental discovery that we're entitled to without a motion, and they're ignoring our motions for it, I mean, they're not prosecuting the case, and it's a lack of prosecution. And I think the court, anytime on the record that we've assembled today, could dismiss this case for lack of prosecution, both of these cases. You know, there's no written motion before you, but I want to ask the court to enter an order that, you know, within 14 days, everything needs to be complied with, or you will entertain a motion for dismissal due to lack of prosecution. And I'm sorry that falls on present counsel's feet, but I'm not hearing that Attorney Mello's off the case. So if this is still Attorney Mello's cake that he's baking, then he's on the case, and let's make it happen. And that would be my request, Your Honor. Thank you.
Yeah, Cosgrove, is that a realistic time frame for you to ensure that the outstanding items, I know you just received notice of it today,
No.
What's realistic?
Give me 30 days, Your Honor.
Folks, quiet, please.
I would note that I'm not convinced that all of the things listed are missing are what I would call mandatory discovery, but I will look into them all nonetheless.
Okay. Attorney Bradl, in the 2024 case that you had filed a motion for specific discovery in that case, outlining the items that you were looking for, those contained within the chalk that was submitted?
Your Honor, I haven't received any response to the motion per se. You know, I think it should be responded to by the Commonwealth, and I would like a written response at some point to the motion. I don't know what, you know, there's probably some things that comply in here, but, you know, there's a list of it's about a dozen things, Your Honor, 13 things. I know it's certainly not completely responded to or complied with. So I think that I would ask the court to hold the Commonwealth's feet to the fire, provide the written responses, provide what they're willing to provide without a court order, and then we'll litigate whatever remains so that we don't have to burden the court with going through 13 items. So I would ask for a response, and maybe in the 30-day time frame, I would ask for that, my motion be responded to in writing so we can kind of frame the issues.
Okay. Has there been a response to your request for a bill of particulars that was ordered on the last date?
No, Your Honor.
I can tell the court that I'm aware that Mr. Mello was working on a bill of particulars because he called me at one point with a question relative to the response, but where he was in the process before his surgery, I'm unaware.
Okay. All right. And on our last day too, Attorney Bradl, you had filed a Rule 17 motion seeking records from a third party as well as directly from the record holder. I issued an order after our last hearing, a notice be given by the Commonwealth to the third party as well as the record holder. ADA Cosgrove, do you know whether that occurred for today's hearing?
I'm not aware that notice was given. The third party is here today, but I don't believe that she was notified. I'm happy to take care of that today if I can, Your Honor.
Okay.
In terms of giving her notice.
So, Judge, I'd ask you to allow the motion. This is essential discovery. I'm not going to reiterate my written motion, Judge. We laid it all out there. The government's own reports that have been disclosed to us note that Ms. Cahillane deleted items from her phone. She told the policeman, "I'm deleting things right now," literally said that. And the policeman, the officer, recorded that in his report. So we have an absolute good faith basis to see that she destroyed evidence. So the Commonwealth has given us some text messages, and such as they are, there's problems with those too, where there's photographs, let's say, that you can see that there's like 6 attachments and you can only see the top one, the screenshot. So there are issues there, and we'll contact Attorney Cosgrove, and I'm sure we can work that stuff out. But it's a woefully incomplete representation of what we need. And so this Rule 17 motion in these circumstances where she is 100% admitted to destroying evidence, we need the evidence from the third party because she destroyed her copy. So we're asking that the provider give us all records of Ms. Cahillane's cell phone so that we can hopefully see what was there, what was destroyed, and at least isolate. Some providers, they can give you all the text. Some providers don't have it. We have to try to reassemble the record and see what she deleted. And if she's deleting text messages between her and the police, that's important. And she's also, another point on that, Your Honor, is that Attorney Mello is, I would contend, improperly speaking with Ms. Cahillane in cell phone conversations. And he's now a witness.
That may raise that issue down the road as well, too, in terms of the prosecution of that particular indictment of whether.
So there's all these issues that I just want to litigate this case, Your Honor. I want to get my discovery, and I want to litigate this case. Just a constant stream of drama from Attorney Mello that I don't need. I want to represent my client, and I want to get this done. And I can't do it.
I'm certainly confident in ADA Cosgrove's ability to compile everything and to get it to you within the 30 days. ADA Cosgrove, so you're aware that there were orders issued after our last hearing for everything to be provided by May 8th. I know you're just coming into it, but I just want to make sure you're aware of the framework.
I know that with respect to discovery, Your Honor. some of these motions I am frankly learning about for the first time. I have just learned about yesterday. With respect to the motion presently before the court that Mr. Bradl asked that you allow today, my understanding of Mr. Bradl's proposed next move from the defense is that he's looking for additional discovery from us so that he can file a McCarthy motion or something of that nature. I would suggest that the phone records that he's seeking are not implicated in any McCarthy motion. It may be that he's missing some grand jury minutes, which I don't see any reason why I should not be able to get to him quite quickly now that I've been provided with the specific grand jury minutes that he's missing. But it seems that any use of the cell phone information he's seeking, if indeed he's entitled to it, is something that could be done post-McCarthy motion. I don't see any harm in deferring ruling on this motion to give the alleged victim, who has a statutory right, I believe, or certainly a right under the rule, to be here, to be notified, to be represented by counsel, and to be heard on whether or not Your Honor is going to order that her cell phone records be turned over under a Rule 17 motion. If the ball was dropped in giving her earlier notification, I'm standing here representing the Commonwealth. I'll take the hit for that, but I don't think the alleged victim should be punished, particularly when the problem can be so easily rectified. I make bold to say that this is probably not the first time that a prosecutor has stood in front of you and you have inquired, was the third party given notice of the Rule 17, and had the answer back, no, Your Honor, that didn't happen. And I'm sorry it didn't happen in this case, but I think it can be done and proper procedures can and should be followed.
All right. That brings us into the next issue on the motions that you had filed with regards to that particular witness. Are you prepared to address those, Attorney Bradl?
With respect to Rule 17, Your Honor, I'm sorry.
With regards to the motions that were filed by ADA Cosgrove.
Oh, in terms of a protective order?
Yes.
Yes, Judge. So in the email that I provided to the court, we pledged to that we would not act on anything and publish anything or use anything.
Okay. And I know, before you go too far, there was also a request that the filings be impounded as well. Are you objecting to
No
that?
objection. No objection, Your Honor.
Okay. I do find there is good cause based on the privacy issues raised in the filings to allow the motion to impound. I did receive your correspondence with ADA Cosgrove laying out how to address that particular issue and to clean that up. So it seems like you've reached an agreement on that. Is that accurate?
Well, I'll let Mr. Bradl speak to that. I don't know if he's assenting to my entire motion or.
Well, so Judge, we talked, and I think counsel's right that we have a agreement for the court, and counsel can correct me if I'm wrong. Counsel asked for either the 30th or 30 days, whichever one is fine with me. 30 days, I think it was, to get a hard drive in a form that they believe is appropriate and get that to me. So we have the drive that was given to us. Many of the alleged sensitive items on there, we can't open, number one. Number two, I ask you to kind of take a look at the global situation here. So the one item that we get that has usefulness to us, well, not the one item, but something that has use to us in discovery among things that are not really very useful. We get this hard drive, and the Commonwealth wants it back. They want us to look through it and figure this out and that out. They're giving us a project. They're not giving us our discovery. And now they want it back, and we can't use what's in there that helps us if we have to give it back. So we don't want to give it back. We want to use it and continue to use it in our preparations, but we're not going to utilize anything. And I don't even know what they're talking about as far as what they are concerned about in the drive. I have a feeling that, and again, President Counsel accepted, I have a feeling that when Lieutenant Tully, I think in a good faith effort to try to comply with that May deadline, gave us the drive in haste to try to comply with that deadline. That's the one thing they did comply with on that deadline, was they gave us this extraction. It's full of exculpatory evidence, and we need it, and we're using it. And the fact that he inadvertently left, school records or whatever else is in there, we're not going to use them, look at them, or do anything with them. We've pledged that in an email to him, to counsel a while ago. So we've agreed to that on the record, and we'll do it here on the record that we're not going to do anything with it. We have it, but how about we get our discovery, and then we'll be happy to give the copy back. We have it, and we're not going to use it. Counsel needs this time to give us another one. Let us use the one we have under those conditions until then, is what I'd ask.
And you and your client have agreed not to disseminate any of the information that is on that particular drive in any fashion?
Yes. I believe the date of the email, I pledged that to counsel, whatever the date of that email was. And from that day on, with respect to the phone extraction, this is just applying to the phone extraction, and that we won't disseminate anything. Absolutely. Just among the defense team, of course, but.
So my understanding is that the Commonwealth will provide the defendant with a appropriate copy of the drive, appropriately redacted, within 30 days, and that at that time, Mr. Bradl will return to us the original drive. And then no use will be made of the information other than, as Your Honor has indicated.
Okay. And Judge, just while we're on this drive, I don't want to belabor this, and counsel and I have had a discussion about it, but I just want to state for the record that it appears there were some, I'll just call them extraction issues with respect to what was given over. And I've spoken to counsel about it, and they're going to redouble their efforts to make sure that everything is accessible and provided.
Right, and certainly in my experience, the files themselves in an extraction report, that you just can't open them without the appropriate software. That's something that you're expert,
Right.
If you have one,
Yep.
it's probably going to be the one to open it. That most of the files you're not able to open without proprietary software to get into those particular areas. So
We went through that, Your Honor. Ms. Healy spent a lot of time on the phone with Celebrate, and that's how we were able to figure out that there were certain things that should have been checked that weren't checked. And we're not suggesting, we don't know what happened or why it was not, but we just want to get an appropriate copy. Okay. And I did talk to counsel about that.
all right.
Your Honor.
Yes.
Having filed a motion to impound my motion, which Your Honor has allowed, trying to be absolutely cautious with it, I provided a copy, of course, to Mr. Bradl, and I filed a copy with the court. Given that the information that the Commonwealth is concerned about, the confidentiality of, is the victim's, may I make a copy of it available for the victim to examine?
I'm sorry, I didn't hear the last part of that.
May I make a copy of it available for the victim to examine? My motion to, the motion relative to the drive.
Attorney Bradl, any issue with that? I think it simply outlines the Commonwealth's concerns of what happened and their steps to address it. So,
I've never seen the Commonwealth sharing discovery with a civilian in an ongoing investigation, but if they want to do that, I don't really know if I have any standing to object, but.
Well, I wouldn't call it discovery, it's her information.
Correct. All right. Madam Clerk, in terms of a...
Yeah, thank you. Oh, wait, oh, you want
Can respond to that in 30 days. We need. Oh, okay. I didn't bring my thing. Okay.
Let's do that then. Yeah, let me, what's that? Yeah, let's do that day. I think that's the 27th is better. No, the 27th is a better day. All right. So 88 College Grove, Attorney Bradl, anything else to address this afternoon?
So Judge, I appreciate you going through all this stuff. So my notes here are Rule 17, disqualification and sanctions, and the bill of particulars. What did the court want to do in terms of deadlines or rulings or?
So that's why I wanted to make sure we had covered everything before we set those
right.
those next dates. So
Okay.
what I'm going to, 88 College Grove, anything else to address?
I think Your Honor has covered the waterfront.
Okay. So I'm going to order, I know you asked for 30 days, but it's going to be 21. So it's going to be June 13th for compliance on the outstanding discovery issues to enable us to have a future hearing on June 27th, Thursday, June 27th, 2 p.m. At that point, we'll address, if necessary, an evidentiary hearing on the motion to disqualify. Also, that will be the Rule 17 will be heard at that point with proper notice given by the Commonwealth to the third party as well as to the record holder.
Your Honor, I'm sorry, I'm away that week in June, I just realized. I wouldn't have an objection to,
That June 13th will be an out-of-court compliance
okay.
date, but Madam Clerk, what's the week before look like?
I think June 21st was the next best date. Oh, no, I'm sorry, that you.
That's when I'm going away, judges, that for the hearing date, I'm going away, from about the 21st, returning July 2nd.
June 20th would be a week from the 13th, right?
Could we?
Does that work for you, Mr. Bradl, if it works for the court?
I just don't want to set it up for failure, Judge. I think I'm away that day as well. I'm
The
sorry.
20th as well?
I think so, yeah.
I
don't have
wouldn't
objection.
recommend July 4th. How about July 11th, if we're looking at Thursday?
Given my issues, I'm not going to object to July 11th, Your Honor, if that's all right.
Do we have our July schedule?
So,
All right. All right, so by agreement, July 11th, 2 o'clock for hearing on those issues. Discovery compliance, June 13th. Anything else, counsel?
And I'm sorry, Your Honor, I'm afraid I'm a little slow today. What matters will actually be on for hearing on the 11th?
It'll be the motion for disqualification as well as the Rule 17 hearing. And if there's any other motions that'll be filed and need to be addressed on that day, if you can get them filed at least 2 weeks in advance, and we can address them that day as well.
Thank you, Your Honor.
Is it Kearney? Kearney, yeah. Kearney, I apologize. Dear Kearney, your matter is continued to July 11th at 2 p.m. for hearing on Rule 17 motions and the motion to disqualify. The Commonwealth shall provide discovery by June 13th.
Thank you.
Thank you.
Thank you.
Thank you, Your Honor.
Madam Clerk, anything else? Do we have a final surrender here? Okay. I'll take a break, yeah.
Order, all right?
Who's that guy? Joe is.